Well, in the middle of Canada's Aboriginal problems, it seems the courts are feeling frisky. One ruling has just added hundreds of thousands of people to the roll of those covered by the Indian Act, and another one may actually say the federal government cannot pass its budget if it affects Aboriginals and they don't like the way they were asked if it was okay. Not sure if this can happen or not, so I've asked Chris Schaefer to join us. He is head of the Canadian Constitution Foundation. Chris, thanks for being with us. What is the core of this lawsuit?
The core of the lawsuit basically comes down to a feeling on the part of two First Nations groups in Alberta that their treaty rights under Section 35 of the Constitution grant them consultation rights, and they feel that the legislation, the omnibus federal legislation budget bills were passed and they affect their treaty rights and their traditional Aboriginal lands, and they feel that this is unconstitutional, and they're seeking judicial review at the federal court.
And is there a particular complaint, the stuff about the navigable waters? Is it the thing about changing the rules on leasing?
Yes.
Or is it kind of a grab bag of everything?
Well, it's a bit of a grab bag. It is a navigable waters legislation that they feel when they take away federal power to oversee that, or reduce the number of navigable waters that are subject to protection at the federal level, that they feel that this violates their treaty rights, because it's the treaty rights that they feel protect their traditional Aboriginal lands. And there's a whole host of other things that they feel are affected by the omnibus legislation, including elections for resource approval on native lands.
And if I'm understanding correctly, their complaint is they weren't consulted properly. Does that mean that, having been asked their opinion, they were not then obeyed in everything? Or are they saying, well, you should have phoned, you didn't?
It sounds like it could be a bit of both. I haven't seen the actual launch of the litigation at the federal court. I understand it was launched yesterday. I haven't read any of the documents that were filed at the federal court, so it's hard to say at this point. It's very early on in this process, but I think you've probably hit the nail on the head, John.
And to me, this is odd, because one of the things that is strange about the whole Chief Spence thing, she wants meetings between the government and First Nations, that such meetings take place all the time. The federal government is constantly consulting with Aboriginals. There are over 600 bands. What obligation does it seem to have constitutionally to seek the opinion of Aboriginals before passing measures that might affect them?
You're right. They're constant negotiation, consultation, contact with First Nations, as well as you know, other interest groups and Canadians from across Canada. So this is ongoing. It happens all the time. The minister has those responsibilities. There is the fiduciary responsibilities of the Crown to First Nations in this country. And I guess the question is, was that consultation sufficient? And is frankly any consultation sufficient to meet the demands of First Nations when they don't get what they want?
Yeah, and that's a tough one, because I gather the court position so far, the 2004 ruling said that although it's not very clearly defined, it must be sufficient to uphold the honor of the Crown.
Correct.
And I think you can tell pretty clearly from Chief Spence and other Aboriginals who share her view, the honor of the Crown has not been upheld, so we're catastrophically short of the standard. But the danger is that the courts are going to give any one of 600 Aboriginal bands veto power over the federal government's ability to do anything important.
Well, they've already, correct, they've already got the veto power over resource development in this country, as we know. There was a book published recently by Bob Gallagher that looks at 171 court decisions, and they're overwhelmingly in favor, the case law is in favor of Aboriginals with respect to a veto over resource development. And in a time in this country's history when resource development is key, and the Northern Gateway, other pipelines are being blocked by the environmental and Aboriginal movements, this is a scary proposition for the future of this country and its success and wealth development. The fact that this wealth creation that these pipelines provide, the First Nations themselves rely on that wealth in order for the federal government to continue pumping hundreds of millions of dollars into reserves across Canada.
Yeah, to me, and this is one of the tragic things that, and I recognize there's enormous frustration among Aboriginals in Canada about the course of history and the state of affairs today, and they seem to have discovered that the one thing they can reliably do is stop things from happening in ways that annoy people. And they do that not necessarily because they should, but because they can. It's the one way they can get noticed. And it's become something of a reflex habit. It's just no to everything.
Yes, we see that time and time again, and it's where I see some of the more positive developments are in certain First Nations that recognize resource development is key to Canada's future, but also the future of the Aboriginal people that they represent, and are moving forward in lockstep, sort of with the Harper government, looking at private property protections on reserves so that Natives can have private property and all the benefits that flow with that, including bequeathing that to future generations, that wealth, and also using that wealth to gain credit and build businesses on native reserves, plus education reforms that Harper has put forward, as well as a variety of other measures such as accountability on native reserves. All these things, some groups within the native establishment see as positive steps forward, and I would argue are positive steps forward, and are working with the Harper government to achieve those ends.
Yeah, and that's what I find so odd about the narrative of people like Chief Spence, that basically has been 500 years of cultural genocide, if not the physical kind, that you do see all this movement on the part of the government, and then coming back to your area, the law, that court rulings have overwhelmingly favored Aboriginal claims. You'd think somebody out there would be getting the message out to Aboriginals. It is no longer true that the government, speaking broadly, all three branches, legislative, executive, and judicial, is completely and contemptuously hostile to you. Those days are gone.
Yeah, I would agree. If anything, the case law to date shows that the courts are overwhelmingly in favor of interpreting the Constitution and statute and a variety of other things, regulations in favor of Aboriginals. And I would argue, from what I've seen from the federal government, at least since the Conservatives were elected, a very honest effort to sort of get away from this old attitude about it's all about the constitutional, legal, political fight that we saw in the 60s, 70s, and 80s, and more towards a fight or sort of a process that looks at what do Aboriginals on reserves need in order to be successful in a modern economy. And those are education, private property rights, and a variety of other things that they're moving forward with currently.
And you could certainly ask a worse question, and you could certainly get a worse answer. Chris Schaefer of the Canadian Constitution Foundation, thanks for joining us.
Thanks for having me, John.